Hello my dear friends, good morning again, and today I just want to take you through relevant principles relating to written statement. And you're all very well aware, Order 8 deals with Order 8 Rule 1. That's precisely what we generally, before you dictate that, the typist will type that. You dictate the cause title, plaintiff and defendant, and then he would naturally type the heading, written statement filed under Order 8 Rule 1 CPC, filed by, sir, which defendant? Third defendant. So filed by the third defendant. All the material allegations made in the plaint are not true, valid, and tenable, and such of those allegations. We all got it by heart. Even the typist also got it by heart. So they will type the first paragraph also. But before you think of filing the written statement, after your client brings you the court summon and you file the wakalat, then you have another option also. If the plaint is barred under law, or if the plaint is not in order, if the court fee is not properly paid, if the cause of action is not there, if the suit is barred by any law, then you can invoke Order 7 Rule 11. You can file an application. Without filing your written statement, you can file an application seeking rejection of the plaint. So that is one option every defendant has. If the plaint pleadings, by going through the very pleadings and the documents that are being relied upon by the plaintiff, if anybody can conclude that the plaint is not valid under law, if it falls under any of the categories that are enunciated under Order 7 Rule 11, then the plaintiff can immediately file an application under Order 7 Rule 11 seeking rejection of the plaint. Be it noted, my friends, that the contention of the defendants, that is the contents of the defense of the defendant, or the contents of the written statement are not relevant for the purpose of invoking Order 7 Rule 11. It is only the plaint allegations that are relevant. Going by the pleadings in the plaint, if the court can come to a very positive conclusion that the plaint is bad under law, it is prohibited under any of the enactments, or there is no cause of action made out, not incorporating a paragraph, the cause of action for this suit, that is not it. By reading the plaint, there must be a cause of action. By reading the plaint, you must understand that there is a cause of list. There is a cause for filing this particular suit. That's called cause of action. As we are all used to, we write cause of action in paragraph 4 of the plaint in this part of the country. In Andhra Pradesh, that's how we draft. We are trained to draft like that. Paragraph 4 is the cause of action. Cause of action for this suit arose on so and so date. Therefore, the suit is within the territorial and peculiar jurisdiction of this honorable court. That's how we are trained to draft your plaint. If paragraph 4 is not there, doesn't mean that cause of action is not there, according to me. The very reading of the plaint, if no cause of action is made out, then the plaint is barred under Order 7 Rule 11. It can be rejected. So this is one option which the defendant can exercise before he thinks of filing a written statement. There are also another situation where there is a suit filed, the plaint is presented and the suit is registered, and the contract between the parties contemplate arbitration. Then the defendant is not expected to file an application under Order 7 Rule 11, but he will file an application under Section 8 of the Arbitration Conciliation Act, seeking reference of the dispute to arbitration, because he cannot seek rejection of the plaint. Rejection of the plaint is nothing but termination of the list. The suit is as good as dismissed immediately at the very threshold. So that stage is barred. Beyond that, you have to file your written statement. And at what stage you are expected to file the written statement, and what is the timeline prescribed under Order 8? The very first sentence reads like this. Order 8 Rule 1. The defendant shall, within 30 days from the date of service of summons on him, present a written statement of his defense. So, my dear friends, within 30 days from the time your client receives the summons, if the summons are served on your client or the defendant on the 1st of April, he must present his written statement on or before 30th of April. Even if the suit is listed for hearing on the 1st or 2nd of May, he is supposed to file the written statement within 30 days from the time the summons are served on him. That's what Order 8 Rule 1 says. But of course, for various reasons, courts are very kind and nice and lenient in extending the time. So we tend to file our written statement 30 days after, and then we seek time for filing the written statement, and it is generally granted. It's all because of the kindness of the courts. The courts are lenient. The courts are extending the time, taking a very lenient view, doing a lot of favor. Because there are very practical reasons where you may not be in a position to prepare and file your written statement within the time stipulated under law. For various reasons, for example, you are ready to prepare the written statement, but your client, after signing the wakalat, had to suddenly, for an emergent reason, had to leave for America, or hospitalized for some illness. He is not discharged, he is unable to move, he is paralyzed, he underwent massive surgery. So he could only see you, later, to the time stipulated under the Code of Civil Procedure. Even then, the courts are lenient. The court said, no problem, receive the written statement. But of course, there are certain riders given. So in principle, the written statement is supposed to be filed within 30 days from the time the summons are served on the defendant. Next, further, provided that there is a rider to this, provided that where the defendant fails to file the written statement within the set period of 30 days, he shall be allowed to file the written statement on such other day as may be specified by the court for the reasons to be recorded in writing, and on payment of such costs as the court deems fit, but which shall not be later than 120 days from the date of service of summons, and on expiry of 120 days from the date of service of summons, the defendant shall forfeit the right to file the written statement, and the court shall not allow the written statement to be taken on record. So, the Order 8 Rule 1 further said, you must file it within, you shall, the defendant shall file the written statement within 30 days. Then, if for any reason you could not do that, the defendant is unable to do that, then the court, by recording the reasons, can extend the time by 90 more days. That means 120 days, 30 plus 90 days. So, the Code of Civil Procedure had given time to the defendant to take 3 months' time, to take 4 months' time, 120 days from the time the summons are served. So you are expected to file the written statement within this particular time, and then file it, and then proceed with the trial. And there is a situation where the written statement is not filed even beyond 120 days. Then, what is the situation? The courts have been always kind. Always, courts have always been kind. They were allowing the application and accepting the written statement. But in the very recent judgment, very recent judgment, you may note down 2020 Volume 2 Supreme Court Cases SCC page 708, the court had taken very pungent view. The court had literally pounced upon the defendant for the delays he had caused, for the time he had taken for filing the written statement. And the court made this remark: repeated delays, non-adherence to the deadlines, although the unamended Order 8 Rule 1 CPC is discretionary, it cannot be interpreted to bestow a free hand to the litigant to file written statement at his sweet will. Deshraj versus Balakrishna. the judgment dated 20th of January 2020, reported in 2020 Volume 2 SCC page 708. The court had literally thrashed the defendant, skinned him alive, found all reasons why the application seeking acceptance of the written statement should not be allowed. But at last, in the last paragraph, court again took a very lenient view and said, you pay 25,000 rupees costs and then file the written statement. Why I am saying this is, even in this judgment, Supreme Court allowed the application and received the written statement, but it doesn't mean that it is a matter of right. Every court has a discretion. Every court has a reason to disallow or dismiss your application seeking acceptance of the written statement into the record. So, my dear friends, it is always mandated to adhere to the timeline which is prescribed under law. That is 30 plus 90 days, 120 days maximum. And if it is beyond your point, visualize a situation where in a situation like this, the COVID situation, you file your wakalat and the written statement is supposed to be filed within 120 days. And your client left for, say, America or Germany or Japan for one of his business trips or his personal reason to attend his son's graduation ceremony in America, and he is stuck. He is stuck beyond 3 months. So by the time he could return, it is about 4 months, 5 months. He could not file the written statement within the time stipulated. So, in those situations, the courts have been very lenient. Accepting the circumstances, the courts have been allowing the application, accepting the written statement to be taken on record. But my dear friends, to the extent possible, unless the situation is beyond your control, it is beyond the control, your control means beyond the control of the defendant, the written statement better be filed within the time stipulated. So this is what is the judgment relating to the timeline which the defendant is expected to adhere to for the purpose of filing the written statement. Now there are certain circumstances. If you file an application under Order 7, Rule 11 seeking rejection of the plaint, okay, then there is a law. There is case law to say that the court cannot insist upon filing of the written statement. First of all, the court must decide my application under Order 7, Rule 11. Court cannot say, no, you did not file the written statement, defendant at ex parte. No. The court must dispose of your application under Order 7, Rule 11, and this application is allowed. The question of filing written statement doesn't arise. But if the application is dismissed, then the court will have to necessarily fix a time for the purpose of filing the written statement. This rule, that means as long as the application under Order 7, Rule 11 is pending, court cannot insist upon filing of the written statement. Has a rider, I'll explain it. So this 120 days time for the purpose of filing a written statement is capable of being extended depending upon the circumstances involved. But this rule of 120 days is mandatory in the suits relating to commercial courts. Be it noted, my friends, that there is no extension of time. The court shall not extend the time for the purpose of filing the written statement beyond 120 days in suits before the commercial court. This is the definite rule, and the amended Civil Procedure Code and read with the provisions relating to the Commercial Courts Act restricts the authority of the court to extend the time beyond 120 days. Therefore, in all commercial courts, the written statement must be filed. Note it, my friends, I am repeating, it must be filed, and the court has no competence to extend the time beyond 120 days, and this rule has been approved and settled by the Supreme Court in its judgment reported in 2019, volume 4, scale, SCALE, page 574, SCG Contracts Limited versus KS Chamankar Infra. SCG Contracts Limited versus KS Chamankar Infra. Therefore, in these suits, if you are appearing for the defendant in a suit before the commercial code, COS, that's how the suits are numbered in our state. If you file the wakalat within 20 days from the time the summons are served on the defendant, you must file the written statement, and if you fail to file it, your right is gone. Whereas, I said earlier, the application, if an application is filed seeking rejection of the plaint in Order 7 Rule 11, under Order 7 Rule 11, then you can take protection. You can take protection under law. You can say that, Your Honor, my application under Order 7 Rule 11 is pending. Therefore, you cannot insist upon my filing the written statement, the regular civil suit. For example, in the case of commercial courts, there is a prohibition under the enactment itself. The time limit is prescribed and fixed. It is 120 days. In that particular suit, for example, you filed an application under Order 7 Rule 11. In a commercial suit, you filed an application under Order 7 Rule 11, you are entitled to file it. Every suit, you are entitled to file an application under Order 7 Rule 11 if the contents of the plaint fall within the categories that are enunciated under Order 7 Rule 11. Therefore, you file the application along with the wakalat in 30 days from the time you receive the summons. You file the wakalat and also an application under Order 7 Rule 11. So, this pendency of Order 7 Rule 11 application will not be extending your time. My dear friends, in commercial courts, when the time limit is prescribed for the purpose of filing the written statement, a mandatory time limit is prescribed, then pendency of Order 7 Rule 11 application will not be extending your time. You cannot take advantage of that. Application filed under Order 7 Rule 11 cannot be used as a defense for non-filing of the written statement within the statutory period. So, in commercial courts, the filing of the written statement within 120 days is a statutory directive. And this principle has been laid down by the Supreme Court in its judgment, reported in, you may note down, 2016, volume 14, SCC page 275. I repeat, 2016, volume 14, SCC page 275. R.K. Raja versus U.S. Raidu and another. So, in the regular civil courts, when you file an application under Order 7 Rule 11, there is extensive case law on this line. The court cannot insist for the filing of the written statement when an application under Order 7 Rule 11 is pending. But you cannot take advantage of that particular principle and say that, no, since Order 7 Rule 11 petition is pending, I will file my written statement beyond 120 days. You cannot make that argument, especially in commercial courts, because in view of this particular judgment. Therefore, my dear friends, the written statement under the provisions of Civil Procedure Code is expected to be filed within 120 days maximum. Okay? And if there are circumstances which are beyond your control, then the court is competent to extend the time beyond 120 days also. By recording the reasons, you file an application, court will use its discretion generally in your favor, generally, and then allow the petition and accept the written statement into the record. But this discretion is not available in commercial courts. My dear friends, I am underlining this. You must file your written statement within 120 days. within 120 days from the time the summons are served on the defendant. That is what it is in the written statement. It is written statement says, the provisions relating to written statement says. There is another situation in commercial courts. For example, originally the suit is filed before this particular enactment. Originally the suit is filed in the regular civil courts. Say before the suit is made over to the 4th additional district judge or 5th additional district judge. The suit is based on a commercial contract and the suit is for the recovery of say about 15 crores. For various reasons, the time is extended for filing the written statement. 120 days what? 5 months, 6 months over, 7 months over, 1 year over. Due to maybe the non-availability of the officer in that particular court, the matter was just getting adjourned. After 1.5 years, after you file your written statement, the matter is made over to the regular commercial court. So, in the very first hearing, okay, the suit is renumbered OS 20 of 2019, which is filed in the month of say February 2019. He is made over to the commercial court and it is renumbered as COS 10 of 2020. And the notices of appearance is given on the served on the parties to the suit, and you appear before the commercial court on the say 2nd day of April. Now, the Commercial Court Act and under the provisions of the Commercial Court Act, the written statement must be filed within 120 days. The suit is actually originally filed in the month of February 2019 and it is made over to the commercial court in the month of April 2020. So, the time you file the wakalat, the plaintiff counsel will have to necessarily stand up and say, Your Honor, the written statement cannot be received now because you have to necessarily place the defendant ex parte because the written statement is not filed within 120 days as contemplated under the provisions of the Commercial Courts Act. Now, the query is the plaintiff right, or at the same time, can the court place the defendant ex parte and proceed with the recording of the evidence? No. No. This particular provision relating to filing of the written statement within 120 days in commercial courts is applicable only to the suits which are filed before the enactment came into force. So, this provision is not applicable to suits which are transferred to the commercial court at a later point of time. So, once the suits which are filed in various other courts, regular civil courts, are transferred to the commercial court, then the court will have to necessarily give a fresh date, fix the time for the purpose of filing the written statement, and despite and if the defendant fails to file the written statement within the time stipulated by the courts, then maybe the punitive action will follow. So, the suits which are filed prior to the enactment of the Commercial Courts Act, the mandatory timeline of 120 days to file the written statement is not applicable. You may note down this judgment. I could not find the citation, but you can Google this. Reliance General Insurance Company Limited, Reliance General Insurance Company Limited versus Colonial Life Insurance Tribunal Limited. I am repeating, Reliance General Insurance Company Limited versus Colonial Life Insurance Tribunal Limited. So, the suits which are filed prior to this particular enactment, the Commercial Courts Act, and made over to the commercial courts from various other courts within its jurisdiction, then the commercial court will have to give a fresh date for the purpose of, fix a fresh date for the purpose of filing the written statement, and if it is not filed within the time stipulated by the court, by the commercial court, then your right to file the written statement is forfeited. Therefore, this provision of filing the written statement within 120 days is applicable only to the original suits that are filed in the original commercial court. If the suits which are filed prior to the filing prior to the advent of the Commercial Courts Act, if the suits are filed in various other courts and are transmitted to the commercial court, then the commercial court will have to fix a fresh date for the purpose of filing the written statement, but the commercial court cannot place the defendant ex parte because the written statement is not filed within 120 days from the time the summons are served. So this is a small twist in filing of the written statement and the time limit granted under the provisions of CPC and the provisions contemplated under the Commercial Courts Act. So this is what the written statement is. And here, I just want to explain a few general principles relating to written statement. My dear friends, according to me, preparing the written statement is much more difficult a task compared to the preparation of a plaint. The plaintiff will pick up his documents of title, prepare his brief, file it into court with whatever reliefs he thinks he is entitled to. But while preparing the written statement, my dear friends, you should be very cautious. It is not just give the papers, plaint and documents to the typists who sit in the court verandas and ask them to prepare the written statement. No. Try to do little homework. Barring certain plaints maybe relating to promissory notes and chit fund cases, generally every suit, every plaint is not just promissory notes. Generally, there are a variety of cases, variety of litigation. There is a huge variety. So when your client brings the plaint into your office, when you are going through the content of the plaint, you should be able to assess what are the enactments you must go through. For example, there is a document of title being relied upon by the plaintiff, on the strength of which he filed the suit for declaration of title. And the documents being relied upon by the plaintiff are revenue records, for example, or the patas issued by assignments issued by the government. Then you may have to go through the relevant law relating to assigned lands and the permissions. Whether the assignment is there, then what is the right of the plaintiff's vendor to sell that. Whether that alienation is valid under law. Similarly, entries in the revenue records. Whether the entries in the revenue records confer title on the name of onto the person whose names are incorporated in the revenue records. And then if the document being relied upon by the plaintiff is a will, whether the will is validly executed, where the will has two witnesses as contemplated under law, where the will has the character of a will, well, the document of being relied upon by the plaintiff has the character of a will. What are the contentions? What is the content of that particular document? Is it within the scope and ambit of the principles laid down by courts of law? Whether the document, if it is to be registered, whether it is registered. If the document is to be stamped, it is properly stamped. So, if the contract being relied upon by the plaintiff is validly enforceable contract, so you have to go through Stamp Act, you may have to go through the Registration Act, you may have to go through Contract Act, you may have to go through maybe Benami Prohibition Act, you may have to go to Assigned Lands Prohibition of Alienation Act. So, my dear friends, preparation of a written statement is just not filing a reply. All the material allegations made in the plaint are not true, valid, and tenable. Allegations in para 3 are not true. Allegations in para 3b are not true, valid, and tenable. We tuned our minds to sometimes to deny everything. The suit relating to partition, the plaintiff will have to necessarily say that the first defendant is my father, second defendant is my brother, third defendant is my sister. Okay, this is paragraph 3A of the plaint. There are certain written statements in which the defendants deny that relationship also, because he's trained like that. He is trained to say, no, you deny everything that is incorporated in the plaint. My dear friends, you cannot deny everything and anything. You may have to sometimes accept and admit certain allegations. For example, the vendor, your vendor and the plaintiff's vendor, for the sake of illustration, I'm telling you, Mr. A sold the property to you, a property which he owns, the only property he owns. Okay, about 167 square yards of plot in MEP colony. He bought from Visakhapatnam Urban Development Authority. The only property he has is that, and he sold that to you in 1997. You did not occupy that property because you are living in the US. It is only the symbolic position that is delivered to you. It is a vacant land maybe. And he did not take the original sale deed also, trusting the vendor. And this gentleman alienates the same property to Mr. B in the year, say 2020 or 2010. 10 years after he sold the property to you. Then he files a suit against you for declaration of title. He says that my vendor is one Mr. X, and he purchased the property from Visakhapatnam Urban Development Authority in the year 1987, and he executed a sale deed in my favor in the year, say 2010. You cannot deny the title of the vendor because you are also deriving your title from the same vendor, right? So you have to necessarily admit that Mr. X is the owner of the property, but you have to say that since Mr. X sold the property to me in the year 1995 itself, the subsequent alienation is invalid. Therefore, simply denying everything that is incorporated in the plaint is not correct. You cannot deny everything and anything. You have to sometimes admit certain things. Because when the vendor is a common vendor, you cannot deny the title of your vendor. You have to necessarily say that yes, he is the owner, but my title, he conveyed his title to me in the year 2010, and he conveyed the so-called title to the defendant in the year 2015. Therefore, later to my sale deed, therefore my sale deed is valid. So this is how the drafting of the written statement is. You are expected to be very careful. You should acquaint yourself with all relevant enactments relating to the contentions that are raised by the plaintiff in the plaint. Sometimes Hindu law relating to partition, succession act. You may have to go through contract enactment. You have to go through the arbitration enactment. When you are going through the plaint, you should be able to assess what all enactments you may have to necessarily touch for the purpose of preparing this written statement. Sometimes case law also. Try to dig into the case law, whatever is relevant to you. Therefore, preparation of the written statement, according to me, is not as easy as preparation of a plaintiff. Plaintiff can file the written statement just like that. Written statement, you must take enough time, but you have to file it within the time stipulated under law. Similarly, how the content of the written statement should be. Can you simply say not true, valid and tenable? Can you simply say, I don't admit that? All the allegations are denied. The paragraph 3b gives a detailed account as to how the plaintiff had derived title to the property. Detailed account as to how the defendant had committed default in performing his part of the contract. Detailed account, para 3c, gives a detailed account of what the plaintiff had done for the purpose of discharging his part of the contract. He gives a detailed account, day-to-day chronological account of what he had done. And you say all that, the contentions raised by the plaintiff in para 3b of the plaint, that, and then as not true, valid and tenable, are not admitted by the plaintiff or not admitted by the defendant. This is not the way you are expected to dispute or deny the contentions which are raised by the plaintiff. The defendant should specifically deny the allegations. If the plaintiff says that he had entered into a contract on so and so date, and in pursuance of the contract, he supplied, say, 10 tons of iron ore to the defendant by way of invoice number so and so so and so. His allegation, the defendant must specifically deny this allegation. I specifically deny that the plaintiff had supplied 10 tons of iron ore to me on the strength of the alleged invoice dated so and so so and so. He may further explain. He may have to explain, saying that maybe invoice is the document which is created by the plaintiff, but there is no acknowledgement from my side. I did not receive even a single ton, single gram from the plaintiff. Therefore, there is no acknowledgement relating to the receipt of the material from the plaintiff. This is how the denial should be. You should be specific, and vague and evasive denials are not acceptable under law. This is what order 8 rule 3 says. Denial should be specific. It shall not be sufficient for a defendant in his written statement to deny generally the ground alleged by the plaintiff, but the defendant must deal specifically with each allegation of fact of which he does not admit the truth except damages. So he must specifically, the contention raised by the plaintiff that he said so or he did so, whatever, is specifically denied. It is not a fact. So otherwise, generally what we tend to is the contention in para 3b that the plaintiff had entered into a contract with the defendant on so and so date, that in pursuance of that particular contract he supplied 10,000 tons of iron ore to the defendant under invoice number so and so date, that the defendant had received the said material at his yard located in so and so are not true and tenable. That is not the way you are expected to deny. The denial should be very specific. And then evasive denial. There is another kind of denial called evasive. It may be true. I may not admit that. Not tenable. Not admitted. These are all evasive denials. It should be very specific, and it should be it should not be evasive. And the problem is, if the denial is evasive, then the court is expected to deem it as an admission. That's the most dangerous proposition. If your denial is not specific, by going through the contents of the written statement, if the court concludes that your denial is not specific, it's only evasive, you did not put forth your very confident case before the court, then your denial becomes very evasive. I'm just reading out for your convenience. The specific denial. Every allegation of fact in the plaint, if not denied specifically or by necessary implication or stated to be not admitted in the pleading of the defendant, shall be taken to be admitted except as against a person under disability. Therefore, my dear friends, you are expected to file your written statement carefully, draft it carefully, and deny the allegations raised by the plaintiff specifically. You must deny the allegations specifically. You cannot be evasive in your denials. For example, I just take you through, give you one judgment relating to this particular principle. You may note down Jasper Kaur versus Industrial Trade Links. 2017, Volume 8, 2017, 8 SCC, page 592. In this, the Supreme Court said, a defendant is required to deny or dispute the statements in the plaint categorically, as evasive denial amount to admission of the allegations in the plaint. Failure to make specific denials amount to admission. It is a very dangerous proposition, and if the court deems that the denials are not specific, or if the court concludes that, or if the on the face of the written statement, by going through the written statement, if there is no specific dispute against the allegations which are raised by the plaintiff, then the plaintiff can file an application under appropriate provision of law seeking a decree on account of admission. My dear friends, there is a huge law relating to decree on admissions. I think it is under Order 12. The plaintiff can file an application under appropriate provision of law and seek for a decree in view of the admissions made by the defendant in his written statement. Order 12, Rule 6. Order 12, Rule 6. I am just taking you through that particular provision. Order 12, Rule 6. Judgment on admission. Where admission of fact have been made, either in the pleadings or otherwise, whether orally or in writing, the court may, at any stage of suit, either upon the application of any party or of its own motion, and without waiting for the determination of any other question between the parties, make such order or give such judgment as it may think fit, having regard to such admissions. You understand? Therefore, if the written statement is not very clear with regard to the contentions raised by the plaintiff, if the denials are not specific, deeming this particular provision under Rule 5 of Order 8, there can be a situation where if the court thinks that since the denials are not specific, I am deeming them as admissions, and then plaintiff may file an application under Order 12, Rule 6. This is one probability which you may have to necessarily avoid. You file your written statement with very specific contentions, deny all the allegations specifically, and then put forth your contentions. If you deny the title of the plaintiff, you have to explain how you are entitled to that particular title. Therefore, if you deny that the plaintiff had supplied any material to you, you have to necessarily deny them specifically and also explain as to how the contentions raised by the plaintiff are false. So generally, in terms of the volume, according to me, the written statement will be double the size of the plaint. Generally on the very practical side, because you will be denying all the allegations made by the plaintiff specifically, line to line, date to date, fact to fact, document to document, and then incorporate your contentions into that particular document. So it is denial of the plaint and incorporation of your case put together. That is what a written statement is. Written statement should be, it should contain the factual matrix which your client gives. Your client can only give you the facts relating to that particular subject matter. For example, if the suit is relating to partition or title based on a will on which the plaintiff is relying, then the defendant will have to give you the factual supplements. Whether the will is valid, whether the signature is right, whether the signatory, the witnesses are honest and genuine witnesses, whether there are any suspicious circumstances relating to the execution of a will, whether the executant of the will was in valid and proper state of mind, whether he was hale and healthy, whether he was under the influence of the beneficiary or the propounder of the will, that is the plaintiff. These are all the facts which the defendant will tell you. Legally, what are the other aspects which you may have to incorporate in your written statement is your job. For the purpose of making a complete written statement, my dear friends, it should incorporate both the factual aspects as well as the legal aspects also. Legal aspects generally related to the law. Generally, I prefer law in the core law, not the judge-made law. Sometimes this particular law is so fluid that a judgment relied upon by you today, tomorrow it is overruled. So don't incorporate the judgments in your written statement. The the citations in your written statement. You try to be little evasive. You try to hang on to that one particular line of argument, that should be in tune with the section of law. Don't go into the case law. The judgment which you rely on in the year 2020, by the time the matter comes up for trial in 2022, maybe the judgment is overruled. There are instances of that kind. I still remember we were filing injunctions seeking injunctions against enucation of the bank guarantees. A bank guarantee worth 1 crore or even 2 crores, we used to file them in the subordinate court, senior civil judge court, by notionally valuing the suit. Say about 1 lakh rupees, pay the court fee those days, and then get the suit numbered. In injunction, restraining the defendant from encashing or invoking the bank guarantee. Suits were getting numbered. At a later point of time, I think somewhere in 88, 89, I don't exactly remember, but Justice Neeladir Rao had overruled the judgment. He said the value of the bank guarantee, if the bank guarantee is for 1 crore, you have to pay court fee on 1 crore, because that is the loss which you are avoiding by filing this particular suit. Therefore, my dear friends, the judge-made law, it changes. It is very fluid. Unlike physics, E is equal to mc square, or a plus b whole square is a square plus b square plus 2ab. That is, this kind of principles are not applicable in law. The law sometimes changes very drastically, takes a U-turn sometimes, you are very well aware. Therefore, while preparing the written statement, you try to hang on to the basic law. What is mentioned in the sections? Keep that particular judgments in your armory. Keep them in your armory. Make a pleading which slowly, maybe partially touches the principles laid down by the courts, but don't completely, rely on that 100%. You should have an option to come out of that. You should have an option. Leave the scope, leave a gap, open a door so that you can sneak out. That's how the written statement is supposed to be drafted. So now here, how the written statement should be evasive, should not be evasive. The specific denials, and then if the denial is not proper, the court can deem it as a admission. And then another more interesting principle is relating to set-off and counterclaim. What is a counterclaim? What is a set-off? Set-off is something which, if a plaintiff files a suit against you for the recovery of say 10,000 rupees, then in a different transaction, the plaintiff owe you 10,000 rupees or 5,000 rupees or 8,000 rupees, then you will file a claim for set-off. That is Order 8, Rule 6. Order 8, Rule 6 is a provision relating to set-off. So when a plaint is filed against you, you will file your reply saying that you may say this: yes, I owe the plaintiff 10,000 rupees, but in a different transaction, the plaintiff owe me 10,000 rupees or maybe 8,000 rupees. Therefore, Your Honor may kindly set off these claims. His claim and my claim, set it off. Accordingly, you can file the written statement along with a set off. You have to pay court fee on the set-off amount claimed, and you will be filing your reply to the plaint under written statement filed under Order 8, Rule 1, that is in response to the plaint filed by the plaintiff, and later you will be filing the set-off claim filed by the defendant under Order 8, Rule 6. So you narrate your claim for set-off, pay the court fee, and the court will have to necessarily decide both these aspects together. It is not necessary, for the purpose of claiming set-off, it is not necessary that you must admit the claim raised by the plaintiff. Okay? Therefore, this is what set-off is. Now comes to counterclaim. How many of you filed the counterclaim? I do not know, but counterclaim is another interesting aspect. Counterclaim is something when a plaintiff files a claim against you saying that Mr. X owe me, say, 55 lakh rupees. I'll say 40 lakh rupees. And then the plaintiff comes to you, defendant comes to you, saying that, sir, I owe him nothing. I owe him nothing. Yes, it is true that I entered into a contract with him, wherein he agreed to supply, say, 40,000 tons of, say, manganese ore to me. And the value is 45 lakhs, it is true. But he did not supply even a kilogram of that material. The invoices are prepared by him. There is no acknowledgement. I did not sign any of the acknowledgements. Not a single truck had entered into my yard. There is no document to show that I received the material. Therefore, I did not pay him any money. The contract is right. Yes, I entered into a contract with him, whereunder I agreed to pay him 45 lakh rupees for the supply of, say, so many 10,000 tons of manganese ore. But he did not supply even a single kilogram. Therefore, I need not pay him anything. That is denial. On the other hand, sir, on top of that, in fact, I supplied 50,000 tons of iron ore to him and he owe me 1 crore rupees. Therefore, you raise a counterclaim. Or, because he did not supply the material to me, I sustained loss to a tune of 2 crores because I could not get the material in time for the purpose of manufacturing something in my factory. This is a raw material. He did not supply. Therefore, my equipment had to lie idle. I could not make supplies to my clients and customers. Therefore, I sustained a loss to a tune of 2 crores. Therefore, you file a suit against him for damages. This is called a counterclaim. So here in this particular counterclaim, you are disputing the allegations made against you by the plaintiff, and on top of that, you are making a counter allegation against him. You are saying that, Your Honor, I owe not a single penny, rupee to the plaintiff, but on top of that, he owe me 1 crore rupees or 2 crore rupees, depending upon the quantification of whatever loss that you think you sustained. Therefore, you deny the allegations. So your written statement will consist of 2 parts. One is a written statement whereunder you specifically prepare your written statement, file it, and then the counterclaim filed by the defendant under Order 8 Rule 6A of CPC. My dear friends, earlier, prior to 1976, there was no counterclaim except for money claims. So, by Act 104 of 1976, with effect from 1st of February 1977, this particular counterclaim, Order 8 Rule 6A, is incorporated. So the counterclaim came into existence with effect from 1st of February 1977. So you file the counterclaim, and in the counterclaim, it is like a plaint only. It is a written statement first and the plaint at the last. You have to pay the court fee basing on the value of your claim, and upon receipt of the counterclaim, copy of the counterclaim being served on the plaintiff will become the defendant as far as the counterclaim is concerned. And he is expected to file the written statement within 120 days as contemplated under the Commercial Courts Act, if the counterclaim is in the commercial courts, or otherwise within 120 days as contemplated under Order 8 Rule 1 CPC. Therefore, the counterclaim is nothing but denial of the plaintiff or the plaintiff's claim and making a claim. It's a counterclaim, a counter attack against the plaintiff. I owe you nothing, Mr. Plaintiff, but you owe me this money. And interestingly, my dear friends, I'm telling you how it can be. Interestingly, there can be a counterclaim by one defendant against the co-defendants and the plaintiffs also. Very interesting situations are also there as far as counterclaims are concerned. There are 3 defendants. For example, plaintiff filed a suit against 4 or 5 defendants, and one defendant can raise a counterclaim against co-defendants and the plaintiffs also. Okay, for example, in a suit for rendition of accounts or dissolution of partnership, one partner is put to loss. One single partner, the plaintiff, and all the rest of the defendants, they collude and siphon off the funds of the plaintiff, of one of the second defendant, say. Defendants 2, 3, and 4 in connivance with plaintiff will cause loss to the first defendant. The first defendant is actually the person who invested monies, and they file a collusive suit against the first defendant, making other defendants, other partners as defendants 2, 3, and 4. In such situation, the first defendant has a counterclaim against all the defendants as well as the plaintiff. You understand? Very interesting situation where one defendant can sue the co-defendants as well as the plaintiff and raise a counterclaim also. You try to probe into your books. You can probe into the case law also. You can find many. So this is what a counterclaim is. It is filed under Order 8, Rule 6A. Now another very funny situation. The plaintiff filed a useless suit just for the sake of it, for the recovery of, say, 40 lakh rupees from you, from the defendant. But the defendant had a very strong case against the plaintiff for the recovery of, say, 2 crores. Then the defendant, you filed a counterclaim. The defendant filed a counterclaim against the plaintiff. So the plaintiff comes running to you. Sir, what is this, sir? My claim is only 40 lakh rupees. That's a useless claim. I know that I'll be losing. But the claim raised by the defendant is bigger claim. It's a stronger claim. So what do you suggest, sir? What if I don't contest the suit? I don't attend the court. Allow it to die. So what in the regular suits, if the plaintiff doesn't turn up, the suit is dismissed for default. If the plaintiff is interested in the plaint, he will file an application under Order 9, Rule 9, restore the plaint. Otherwise, the litigation is dead and gone. He may also file an application under Section 5, maybe at a later point of time, if he is interested in continuing the plaint. In this peculiar set of circumstances, the plaintiff thinks that if the original suit is dismissed, then the counterclaim is also dead, because if the OS is dead, the interlocutory applications also will die. He will take that analogy. Or ignorantly, we may also give an advice of that kind, ignorantly. Okay? And I would say, my dear friends, that is a dangerous advice. Because if the original suit is dismissed for default, because of the default on the part of the plaintiff, it doesn't mean that your counterclaim will die. Counterclaim will continue. Similarly, if the reply to the written statement, reply to the counterclaim is not filed within the time stipulated, the court is entitled to grant a decree in favor of the defendant to the extent of the counterclaim. His suit will be continuing. Very funny situation. Can happen. Hypothetical. I don't say hypothetical. It can happen. The counterclaim is presented and the written statement is not filed within the time stipulated, that is, say, 120 days before the commercial code, then the court's options are limited. The court will have to necessarily pass a decree in favor of the defendant if his claim is proved. The defendant will come into the witness box and prove his counterclaim. The suit is decreed, the counterclaim is decreed to that extent, and the original suit filed by the plaintiff will continue. So, this is what it is in Order 6, Order 8, Rule 6B, Rule 6C, Rule 6D, Rule 6E, and Rule 6F. You read all these things. This is what I explained now. Okay? If the counterclaim is, if the suit is dismissed, counterclaim will not die, it will continue. If the written statement is not filed within the time stipulated, the court is entitled to pass a decree as contemplated under the Commercial Courts Act. And now the other issue is, what is the limitation? When can, by what date? What is the time limit stipulated under the Code of Civil Procedure for the purpose of filing the written statement, a counterclaim? There is nothing mentioned here. Order 8 Rule 6A do not speak about. Under Order 8 Rule 1 says within 30 days and then extended period of 90 days. But as far as counterclaim is concerned, it won't say by what date. But it says the pecuniary limited. I will tell you another interesting proposition. For example, if the suit is original claim raised by the plaintiff is before the subordinate court, by pecuniary jurisdiction is within the subcourt jurisdiction or the senior civil judge court jurisdiction, but your counterclaim is beyond, it is say about 2 crores, or it is in the district court jurisdiction, then you cannot file a counterclaim against the plaintiff in senior civil judge court because your counterclaim is beyond the pecuniary jurisdiction of that particular court. Keep this in your mind. If your counterclaim is more than the pecuniary jurisdiction of the court in which the original suit is filed, you may have to pursue your remedies otherwise. You may have to file a separate suit or resort to your other remedies. But you cannot file a counterclaim in a senior civil judge court when the counterclaim relates to your claim is beyond its pecuniary jurisdiction. Okay, so this is one principle you may have to keep in your mind. Now, what is the time limit prescribed for the purpose of filing your counterclaim? In this context, the Supreme Court had been very recently passed a judgment relating to the counterclaims. When should the counterclaim be filed? That is 1 minute. Yes, you may note down. Ashok Kumar Kalra, not Kalra. Ashok Kumar Kalra, I think this is a Punjabi name. Ashok Kumar Kalra versus Surendra Agnihotri. The judgment reported in 2020, Volume 2, SCC, page 394. I am repeating, 2020, Volume 2, SCC, page 394, where the Supreme Court held that once the issues are framed, the counterclaim cannot be entertained. That means any time before the issues are framed, it is not necessary that the courts will frame the issues the moment you file the written statement. Generally. So if it is framed, then by applying the principles enunciated under this judgment, you may have to lose your right to file your counterclaim. So there are instances where the issues are not framed for months together. I think it's in your experience. You must have seen, except under very simple suits related to promissory notes and injunctions. In complicated suits, the courts will ask us to file the draft issues. I'm not talking low or bad about the judges or their learning, but generally, the courts think that we are the best persons, lawyers are best persons to file the draft issues, so that the court will have maybe a better view on the kind of issues which the court may have to ultimately frame. Therefore, in view of this judgment, Ashok Kumar Kalra versus Sundar Agnihotri, the counterclaim must be filed well before the issues are framed, but definitely not later. Therefore, my dear friends, this is simply what the counterclaim is, or the written statement and the counterclaim are. And now, for example, if the written statement is not filed, this is another situation. If the written statement is not filed within the time stipulated, or the written statement is filed but not denying the claims of the plaintiff, written statement can be deemed, the contents of the written statement can be deemed as admissions and the court can pass a decree. And the written statement is not filed and the court is left with the only option of placing the defendant ex parte and pass an ex parte decree. And sometimes we come across certain arguments saying that that's only an ex parte decree, Your Honor. Ex parte decree is as valid or as strong, as binding as any other decree. You may note down this judgment relating to this. Ex parte decree is a very valid decree. It cannot be questioned by anybody till such time it is set aside or declared as void. for whatever be the reasons by a competent court. You may note down the judgment relating to this. 2017, 8 SCC, page 837. Page 837. Expiry decree is a valid decree. And then, once an ex parte decree is passed, what are the options available to the defendant? Should he only file an application under Order 9, Rule 13, or any other options available? Can he prefer an appeal, take an ex parte decree and take it in appeal, or both? You may note down the judgments relating to this. The recourse which the defendant can resort to for the purpose of challenging an ex parte decree. The judgments are AIR 2005, Supreme Court, page 270. AIR 2005, Supreme Court, page 270, and AIR 2018, AIR 2018, Supreme Court, page 753. My dear friends, the defendant can file an application to set aside an ex parte decree, or he can file an appeal against the ex parte decree, going to the district court or the next appellate court, and he can simultaneously do both. He can file an application to set aside the ex parte decree and also file an appeal against the ex parte decree. So this is in simple terms an introduction. I don't say an introduction. A simple explanation, an outlook relating to what a written statement is. Then, and one more thing I have to tell you: if the written statement, you don't take specific defenses, that's the most dangerous part. Your defense should be properly taken, especially on the factual matrix. If you do not take defense relating to the facts, then you are not competent to cross-examine the plaintiff on those lines, and you cannot ascertain these aspects in the appellate court also. So you must make your defense absolutely foolproof. You must incorporate all the facts. Only based on those facts you are entitled to cross-examine. If your cross-examination is beyond your pleading, my dear friends, actually the counsel for the plaintiff can object to you, and the court must have to necessarily sustain that objection. Therefore, if you don't incorporate it in a written statement, you cannot keep. So these are all the things which, unless you actually learn from a senior, I'm sorry to say this, most of us do not intern with seniors. So the good old days, the seniors used to dictate, it runs into hundreds of pages sometimes. A lengthy written statement will be about 50-60 pages, and again it is revised, and then the draft typing, and then it is corrected and the final print. So preparation of the pleading is as good as a yajna. It was like, it will take quite a long time. And most of the old briefs, I still remember, the bundles will have the handwritten written statements and plaints of the juniors. And then it is revised, and it is added, and then it is supplemented with various facts. It is read out to the defendant. If he supplements any further facts, we used to incorporate them, and then shown to the senior, who would prepare the final draft, and then it is typed and then corrected, and then final written statement is prepared for signatures of the defendant. This is the kind of pains we were all trained to take, not just Google copy paste kind of written statements. I am not accusing you, my friends, but I am just giving you the reason to be qualified to prepare the written statement. You must be, because of you, the client shall not fail. Take it as a challenge when you are preparing a written statement, my dear friends. You, as I said earlier, you read all the related subjects. You read sometimes the admissibility of the documents, the Evidence Act sometimes, the Transfer of Property Act sometimes, Registration Act, Stamp Act, Contract Act, many other special enactments. For example, if the suit is based on a Benami transaction, that suit is prohibited under the specific enactment. Benami enactment, it is prohibited. I think it is section 5. You can file an application seeking rejection of the plaint. Civil court is not competent to look into those aspects. Cannot entertain suits related to Benami transactions. Unless you are thorough with these. So you read the plaint twice, thrice, maybe n number of times, then you will understand what is the defense, what is the claim of the plaintiff, and what all defenses that you can take. Only then you have to incorporate them in your written statement in a chronological order. It should be like poetry. By reading the written statement, the court should definitely come to an understanding, at least to a conclusion that the claims of the plaintiff are wrong. That's how impressive your written statement should be. Okay, my dear friends. Hope this is nothing, it's not a lecture, it is just an introduction, I should say, into the aspect relating to written statement in the language that I know, not as a master of the subject, but whatever little I know, I thought I should share with you. You are entitled to supplement this with your learning, make it little more bigger, and then enhance your knowledge and use them. Again, I'm telling you, my dear friends, if we are not strong, the bench becomes stronger. If a bench becomes stronger, then it is wrong. It is bad. The bar should be strong, then only the bench should be. If the bar is weak, the bench can do anything. You will not have legs to stand before the court. You enhance your learning, do better, learn better, stand before the court saying that you should have the confidence to stand before the court and say, Your Honor, you're wrong, this is what this section is, this is what the rule position is. And I think you are respected then. Therefore, my dear friends, do well, all the very best to you, take care, and then soon I'll give another lecture, I think most probably on the rules and case law relating to injunctions. All the best to you and God bless you. Bye-bye.